In our legal system, prosecutors have a unique role and a great deal of power. They're backed by the full investigatory and police power of the government, and the cases have high personal stakes for the defendants and for the victims of crime and for the community. And honestly, most defendants in criminal cases are pro se. They can't realistically afford to hire private defense counsel, but most of them are also not indigent enough to qualify for a free court-appointed lawyer. Thus, prosecutors have special responsibilities and ethical duties beyond the regular rules of professional conduct that apply to all lawyers. And these are the subject of Model Rule 3.8. This is a rule with many subsections or different provisions, and in this first video, I will cover only the first 2 or 3 sections of the rule. You should expect to see questions about Rule 3.8 on my exam in this course and on the MPRE. In practice, to be honest, it's relatively rare to see the State Bar bring disciplinary actions against prosecutors for violations of the rule, but it does happen from time to time. And before we begin, a quick word about terminology in case the students watching this have not taken a course yet in criminal procedure. Federal prosecutors are usually called an assistant U.S. attorney or AUSA, but state-level prosecutors are usually called a district attorney or the DA, at least in most states, including Texas, California, and New York, which are 3 of the most populous states. On the other hand, 8 states, including Florida, call their prosecutors a state attorney or state's attorney. And Virginia and Kentucky call it a Commonwealth's attorney. And just to be different, South Carolina calls prosecutors solicitors. In my course, I usually use the term district attorney because that's by far the most common, but students should be aware that the terminology varies somewhat by state and whether we're talking about state or federal prosecutors. So let's dive in. Rule 3.8a begins with a duty against bringing charges without probable cause. It says, a prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Of course, this is a little redundant in practice because normally the prosecutor would need probable cause to get an indictment anyways, and the police usually need probable cause to get a warrant for a search or an arrest. So in practice, I think it would rarely be an issue except for the decision about whether to impanel a grand jury, knowing that there is no evidence to support an indictment. So let's move on, though, in Rule 3.8 to a section about protecting defendants' rights. A prosecutor in a criminal case shall make reasonable efforts to assure that the accused has been advised of the right to and the procedure for obtaining counsel and has been given a reasonable opportunity to obtain counsel. Now, this is pretty straightforward, but keep in mind that this is also part of the standard Miranda warnings that police give at the time of an arrest. So again, this is rarely an issue when we get to the point where the prosecutor is involved. Let's move on. Rule 3.8c, Section C, is about pro se defendants, those who are representing themselves because they don't have a lawyer. The prosecutor in a criminal case shall not seek to obtain from an unrepresented accused a waiver of important pretrial rights, such as the right to a preliminary hearing. So most non-lawyers do not really see why an arraignment hearing, for example, or a bond hearing really matters. But sometimes important information can come out or important decisions are made in these preliminary hearings that are difficult to undo later. And someone who doesn't have a lawyer may not be aware of that, and prosecutors should not exploit that. This is our first section about Rule 3.8, but we still have 5 more sections to discuss, and those are much more complicated, so stay tuned.